everybody. Welcome to Justice Served Daily. I hope you guys are great. The information, 2 more documents dropped today, and one of them is obviously one we've all been waiting to see. And I downloaded it here a minute ago, and I thought, okay, I need to go through this. And I thought, you know what? I'm going to save time, and I'm going to go through it with you guys, right? I'm just going to do it all at the same time. So I am going to pull this up for us. I hope everybody's doing good, getting prepared for the holidays. If you celebrate Thanksgiving, I know not everything is celebrated in every country, so I am going to go ahead and go through this with you. So this is the weighted document, and the other one is in regards to the prisoner who's going to testify on behalf of Richard Allen, the child molester. So I'll drop that in community stuff for you guys can look at, because it's basically a 1-page motion. So this is the record of in-camera proceedings held on October 19th. I'm going to go to the top of this for you guys can see this. So you can see this was filed today at 3:25 p.m. And you can see this is in response to. So we'll go ahead. And if you hear weird noise, that's maybe my dog snoring. So apologize if you can't hear all that. So let's see what this is talking about. So we have the appearances. It shows Nick McLeland, James Luttrell. We see Bradley Rossi, Andrew Baldwin, the Honorable Francis Gull. Jody Williams is the reporter, so there was a reporter in there. So it's going to go through dialogue and was, typed in there here. So we've got proceedings, attorney Nicholas McLeland, judge, I want to do some introductions. I finally got approved from our council to hire a paid attorney to help me. So we learned this too, right? The court, the judge, okay. Mr. McLeland states small town local government. So this is Jim Luttrell. He's a retired prosecutor from Grant County. He's decided or agreed to come on board. The court, okay, have a seat. McLeland says he signed the oath to my office. She says, okay. And all that, I'm going to handle a written appearance. That's McLeland. So Luttrell, nice to meet you, Judge. The judge, nice to meet you, Jim. McLeland starts next week. Court, so he says, okay. McLeland says, or maybe tomorrow if I have time, Judge, if I get it done. So the judge is okay. McLeland, but he will be entered in, and we're trying to get him up to speed. The court says, okay, well, good. So then Rozzy, well, I'm in the one that kind of asked to huddle up. So he's the one who asked to get together. If you want me to lead, or if you want to say some things. Yeah, I'm sure she did. He says, I'm okay with whatever approach you want to take here. The court said, go ahead. Rozzy's like, well, I think, she interrupts him, I've got Jody's got one portable FTR going just so that we've, and so Rozzy says, oh, okay, that's fine. The court says, got a record. Wow, that's interesting. Rozzy, obviously, I'm happy to hear that the court's going to make some decisions on the pending pleadings today. The court says, right? Like affirmative response. Rozzy, I assume Andy feels the same way. It's time to kind of get some closure, if you will, with regard to those items so that we can move forward. It's probably obvious that the tension from our side is coming, from the words disqualification that were murmured in the phone conference that we had a couple of weeks ago. Interesting, right? So a couple of weeks ago, she said disqualification to them. Obviously, they knew that. We can talk about that later. I'm assuming you understand how that kind of raises the intensity level of the circumstances. And I guess if I have a concern today, is that, we're going to go out on the kind of in the public, so to speak, in the courtroom on the record and have a discussion about an ongoing investigation. Pick that up. We're going to talk about an ongoing investigation. And I think, I'm sorry. And that's what I kind of gathered from the email. I think you invited Nick to talk about that if he wanted to. This is the judge. Rozzy, and it makes me a little uncomfortable because I don't know. First of all, there are no pleadings that are pending, whether they're motions to disqualify or contempt citation or whatever that might be. That really frame any of the issues. And I have no problem. I don't have any problem talking about this stuff privately on the record in an ex parte type confidential hearing. I just think it's a little difficult to expect that there will be any kind of structure to the idea of, hey, there's an ongoing investigation and just tell us what's going on. And I don't know that it has any relevance to what we're really trying to accomplish today. And I also don't know why Nick would want to talk about an ongoing investigation in public, knowing that it in itself could be a little damaging to their circumstances. That's interesting. And so we're lawyers. We're used to having issues framed. We're used to having an opportunity to prepare, and I don't have anything to hide, and I know he doesn't have anything to hide. You've maybe gathered that we've cooperated. We ran into the state police posts, our respective posts, if you will, and I had somebody advise me on my rights, and I waived those. And I gave a formal statement. He did the same. And I'm not sure that we're going to benefit or that this will be productive to just open floor this. And that's my biggest concern today. The judge. She's really talkative, right? Okay, so now Baldwin. I'm more of a like the due process side. I'm not really sure what will happen, but I just don't know. I don't know what's going to happen, and I would like the opportunity to know what's going to happen and prepare for their claiming or whatever before it happens. And I don't feel like, I don't want to say ambushed, but it's hard to know for me what to do when I don't know what's happening. There's not a pleading we can respond to, things like that. So, you had indicated that when Nick said, I don't know if he said the word disqualification, but the court, oh, he did. Baldwin, was it that word? The court, mm-hmm. Baldwin, okay, I didn't know if he just said it in a more generic way. She says, mm-hmm. Baldwin, and your response was, I'm leaning in that direction or something along those lines. Mm-hmm. Baldwin. And so that's, a cause of concern. I mean, we're still wanting to try this case in January, and I'm willing to. We have made changes at my office that will prevent this from ever happening again, and we can take directives from the court. We can, we're locking down every single thing on Delphi. It's in a dedicated room. We put locks on our conference room or the war room where this guy my friend went in and did this without my knowledge. And no document, whether it's benign or something super, like a crime scene photo, is ever going to be left alone for a single solitary second ever again. So, I'm hoping that can be something that the court, can say, all right, that's fine. And then let's get on with the trial. But I'll shut up now. And she says, anything, Nick? So McLeland says, Judge, I guess my plan today was give the court a summary of the investigation. I've got witnesses here and exhibits to present that go towards the investigation. I'm more than happy to hand those over to the defense. I know it may harm the investigation. Wow. But I think it would be important that the court hear these things. I guess the heart of it, something inaudible, investigation. I think it's important. I think the importance of you hearing it is outweighed by that. And so I have those things. I'm concerned that the leak is not just a one-time leak. The evidence that we have shows it is an ongoing leak. However, it's being done, and it's just what's next. Wow. I have an issue what's next. I mean, I spent the past 17 days investigating this night and day when I should have been focused on preparing for trial. And when I say night and day, I mean phone calls at 2 a.m., 3:30 a.m., night and day. And so that's where I'm at, Judge. Again, I'm an office of the court. I'm reporting to the court what I know, and that's kind of where I am, or I'm sorry, where I see my role. The court. Okay. Oops. Sorry. So now we go Rossi. Gosh darn it. Really? Sorry, guys. You, okay. All right, Rozzy. You know, this is starting to scream due process to me. I haven't seen any of these exhibits, and I don't know really, frankly, I don't know anything about any of this. So this is Rozzy saying that, right? And I'm not distancing myself from Baldwin. I'm just saying I have no connection with any of these people, okay? And the idea that somehow the prosecutor is going to get to roll out a bunch of statements and exhibits and, testimony without us having any forewarning or any idea anyway of scrutinizing that seems a little outside the boundaries of due process to me. Plus, again, I get back to what is the relevance to what is going on in the case. Why are we going to use an open courtroom to air an ancillary matter? It's not really connected in any way at this point to the proceedings that are going on or ongoing. Sorry, guys. Whether it's the Franks issue or anything of that nature. And I will tell you this, I am prepared to show the court this. I would rather do it in private. This problem has been a problem from the very beginning. I have 10 pages of a deposition transcript in this file from my deposition, our deposition that I took of Trooper Holman in this case. And in the deposition, he talks openly about how there were crime scene links from the very beginning, unequivocally crime scene leaks. And that as soon as the crime occurred, they were investigating information that had been released because there are lay people that were part of the search party. And the implication is, and I've got the transcript, is that those people that found those girls started to essentially disseminate or distribute information. And law enforcement essentially tried to catch up with them, but it was really too late, as you might expect. Once it gets in the hands of the public, it's too late. How can they say that when they literally have stuff like that? Anyway, sorry, I'm going to be editorial while this happens if you don't know. So he told us that almost volunteered the information to me in this deposition. The second concern I have is that I think I shared with the court, just as an example, a week or two ago, somebody sends me a court TV, bit, and I can assure you I've never watched one of those bits on the case. I don't even know if I've ever really watched court TV. Maybe back when Simpson was ongoing. I don't know. And in that bit, Barbara McDonald is talking 2 different occasions. She mentioned how she's getting information, from investigators on the ground that were at the crime scene. Well, we all have heard that, right? Now we can all draw implications about that, but most importantly, it was corroborated by the fact that she was holding in her hands documents that I know to be directly related to the Purdue report. I mean, I saw the pictures. I know where those came from. And if you know, the point here is I'm going to say this maybe a little loosely, but forgive me. I don't care. I don't care that all this stuff is out there because it's been out there for 5 or 6 years. I don't have time. He doesn't have time. He doesn't have time. Maybe he's pointing, right? I see the visual. To sit and try to marshal all of this stuff while this case is ongoing because there's no end to it. But the point is, in the court needs to have some context that this is nothing new. I disagree, right, guys? It literally shows the girl's crime scene. I'm lost sheep over the fact that there is a man who is dead that I don't even know. And frankly, Andy doesn't know, and it's tragic. So that's R, right, that we know about. If you don't, comment in there and I'll tell you. I don't know what life circumstances he had or what surrounded this. None of this information has been shared with us. But at the end of the day, what's going on in the cyber world and in the public, as you might expect, in a case of this magnitude that's been publicized for 6 years, was beyond our control before we ever got involved. I don't know about that. Oops. Sorry, it keeps opening up something else. And now we're going to go to Baldwin speaking. Isn't it interesting because it's mostly Raw's seat speaking right now. There's even a guy in Florida who says the guy in Texas who leaked all this stuff was received from a disgruntled Carroll County employee, a whole file filled with stuff and photos included. So there's a guy in Florida who says a guy in Texas who leaked it. Interesting. And I haven't even seen the photos that were leaked. I don't know what they are, if this could be set for a formal hearing in the future where we have a chance to do it in the right way, then that's one thing. But to go in there and we don't have any way to counteract anything, if I know what it is, I can, okay, I know what that is, or I don't know what that is. And it's, and in the meantime, we can, I don't know, this is the lowest point of my career right now because somebody did what they did to me and that has nothing to do with Richard Allen. Interesting. You would think if somebody calls you and tells you what photos they leaked from your office, they're going to tell you exactly what they leaked. But so the court says it certainly does not. So the judge agrees with him. So Baldwin says Richard Allen needs to have counsel there. So I just don't want to go in there and not be able to fight back with evidence that we or witnesses that we have. Hold on one second. Sorry, guys. I had somebody walk in the door. So let me continue. I'm going to go back to, I'm just going to start with Baldwin again. Richard Allen needs to have a counsel there. So I just don't want to go in there and not be able to fight back with evidence that we or witnesses that we have to counteract whatever they claim that they have. So here's the court. So here she is. Okay. Here are my thoughts in no particular order. I don't know how many folks are out there, and I certainly don't wish to air publicly to the world the concerns that I have about this matter. My intent in having this hearing was to go through some of the pleadings that we have not yet decided. So I was going to start with reminding everybody about the the decorum order, remind everybody why we're here, to shut up, et cetera, et cetera. There have been reports to my sheriff about disruptive people. And I will remind people, if they are disruptive, they will be removed, and my sheriff is fully prepared to execute arrest if necessary. Wow. Because I know we've seen in our other hearings, people have been disruptive and hateful. So, under the rules, under the canons of judicial conduct, I'm required to advise people within the room that the media is here and that they are filming. They're doing pool coverage. So there's only 2 cameras in the courtroom, and everybody is going to get some coverage from that. And then I want to talk about the pleadings. Defendant filed a verified motion for immediate transfer of custody. The state filed its response. The motion, again, has a lot of inaccuracies and some speculation. And it has been refuted ably, I think, by the affidavit that have been submitted by the state. And I'm going to deny that motion. So we know here she tells them she's going to deny Richard Allen isn't moving out of Westville. The defendant then filed a motion for broadcasting order. The state filed in response, your motion overbroad. It's got a lot of irrelevant verbiage in it, and I'm required to consider individual requests for hearings. So I will, if the media wishes to have an individual request submitted, they know fully well how to do that, and I've provided to counsel all of those requests that I've gotten so far for this hearing. So if you want to file them for particular hearings, you're certainly welcome to do that. But the motion is all over this. I'm sorry, but the media is all over this. They're not. They know how to do this. Rossi, yeah, I was just trying to understand, are you suggesting that you're going to determine that on a case-by-case basis or a hearing-by-hearing basis? She answers, hearing by hearing. Rossi says, okay. The court says, yeah. Rosie says, all right. Okay, I just wanted to make sure I understood that. So now we go back to the judge. The state filed the motion for leave of court to subpoena the third-party records. I think that was directed again to DOC. I clearly can't grant that. I'm going to grant the defendant's motion to quash. So she's going to grant the motion to quash that. But if you continue to raise this medical and mental health in pleadings, that's fair game. Then for that to be provided to the state. You have also filed, Mr. McLeland, a motion for future pleadings and filings to be sealed prior to being released to the public. I've not gotten a response from the defense. Okay, well, this is interesting. So let me go back. So here we have, she's going to quash that they don't get the medical and mental health information. But if you keep bringing it up, that's fair game. And then they're going to get access to it. And they're talking about that there is a motion for future pleadings and filings to be sealed by the defense wants that. Hold on. You have also filed, Mr. McLeland. Oh, I'm sorry. Nope, I got that wrong. You have recently filed that Mr. McLeland a motion for future pleadings and filings to be sealed prior to being released to the public. He had not heard from the defense yet about that. Rossi goes, can I speak to that? She says, sure. I think it's important to note that, we had this discussion come up before, and there was basically, we decided, okay, we're done sealing stuff. We're going to make it public. Before we filed that Frank's brief, I had a long conversation with the court reporter, Karen Allen. Wow, that's a little ironic. Over in Delphi, because I wasn't sure about Allen or Roller. I always want to call her Karen. McLeland says Allen. So her last name is Allen. Rossi, Karen Allen, because I wasn't sure about the mechanics of how all of this stuff was moving from Delphi to your office. And I know that you had set up some kind of a website or something that people could access. And I was under the understanding, in speaking with Ms. Allen, I'm not blaming her for anything, but that when we filed these filings, they were going from them, and then they were hitting a button. We were filing with Carroll County. They were hitting enter, and they were sending it to you, and you were essentially filtering this stuff, or at least you were seeing it before it went public. The judge says no, or nope. So Rossi says, and so that's the way in talking with her, that's the way I understood the mechanics, which I think is what happened to a pleading the other day. From what I understand, we filed something and you either put it in a query. Anyway, I tried to do some homework on that, and that's what then Baldwin says, I was a part of one of those conversations, and that's what she said. The court, does that need a hearing? I'm happy to have a hearing on that. I don't have a problem with that. Rossi, well, I don't really. I guess I'm just telling you for context. That's what Baldwin. I mean, could these be a happy medium of we file it confidentially, and then the judge then gets a chance to review it first? because that's what we thought was going on anyway. But if that's not what's going on, the court, no, it's being filed confidentially if you mark it as such. So Baldwin, I know that now. So the judge says, I had my staff mark the memorandum confidential after it had been filed and disseminated to the public because the actual warrant was in there. And that's covered under a miscellaneous cause number. I'm happy to have a hearing. Rozzy, well, what is your ruling? I guess to make sure I understand, I don't want to fight about something that we don't need to argue about. The court, I haven't ruled on that. Rozzy, okay. You haven't filed a response on that. And Rozzy said, yeah. So the judge responds, my question is, do we need a hearing on that, or do you wish to file a response? The Franks motion clearly needs a ruling, and I'm working on that. So she tells him that she is working on that. The motion and exhibits are about 1,500 pages. And there are hours and hours and hours of interviews that have been made available that my IT staff has now cleaned to make sure they're okay. We already talked about that. And then, that brings us to my concerns that I raised with all of you on our phone call. So it goes to the phone call. And I write everything out. And that is what I intend to say in open court. I have concerns regarding the defense team and the totality of the circumstances surrounding your representation of Mr. Allen. Candidly, my concerns began at our hearing on November 22nd of last year. Mr. McLeland filed a motion for gag order, and we were in chambers, and you assured me, gentlemen, we don't want this. We don't want the media in our lives. We will not try this case in the media. And less than 2 weeks later, you issued an undated press release that contained an awful lot of information that would not normally be revealed. I don't know. I think you knew or should have known those were potentially violation of Rule 3.6 of the Rules of Professional Responsibility. But is that press release that prompted me to issue the order on December 2nd, granting the gag order until further hearing? We all knew that, right? Because they did that, and then suddenly there was that gag order issued after they were all talking to everybody. Okay, so April 18th of that year, April 18th of this year, you filed a notice of tort claim against the Department of Correction. You stated in that notice that it was your intent to pursue our client's claims against you. The full amount of damage sought on behalf of my client is unknown. I don't know how you could do that in representing Mr. Allen in a criminal matter and then launch off into a civil matter. I think that's inappropriate. May of this year, we were notified by the state of the Brandon Woodhouse arrest and the subsequent discovery of your work product. And I think it was an outline that you created for yourselves with discovery. Okay, I knew about that. I knew that Woodhouse was out there talking, stating about that information being out there. He was trying to contact media himself to say stuff, but they weren't picking up on it, right? So, It was pretty detailed. I don't know if that's the right word. That apparently happened in December of last year, and that was not revealed to anybody, not shared with the court. It wasn't shared with you, although apparently you guys knew about what was going on. Baldwin says, we didn't know. And she replies, you knew. And Baldwin said, oh, I'm sorry. Baldwin first said he didn't know. And the court said, you knew. And Baldwin said, I did know. Wow, 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 right? How funny that would have been him, right? That he knew. Okay, the court. So then Mr. Woodhouse gets arrested. And here we are, grossly negligent to email that to the wrong Brad. Your pleadings on the safekeeping order contain inaccurate and falsehoods. That was proven in the hearing we conducted in June. The evidence presented by the state clearly demonstrated the falsity of your claims, and that was very troubling to me. And then the last couple of weeks that we have been dealing with, the state provided you discovery that has been severely compromised. We now have an ongoing investigation. So it's ongoing, guys. I'm not going to call it a criminal investigation. I don't know what it is, but it's clearly being investigated by the state of Indiana. Everyone involved has sought counsel, including you, Mr. Baldwin. You had an attorney enter written appearance this morning. I don't want to get into an investigation candidly. You are the constitutional authority for the state of Indiana. If you choose to pursue it, that is up to you. If you choose to abandon it, that is clearly up to you. I'm glad to hear that you have cooperated. But Mr. Baldwin's attorney has clearly shared, I don't know if you've seen his pleading. So McLeland responds, I saw it, Judge. Yes, I got it kind of late. He emailed us, and then the court says, okay, McLeland, I saw that was filed on the way here. So on his way to court, he sees it. She goes, well, yeah. So he's clearly shared it in his pleading, down to the fact that an individual has committed suicide. He included the fact that you left materials all over a conference room table, accessible to anyone. And this is a friend of yours who apparently you have consulted with on this case. So again, it's up to you if you wish to pursue that. I'm looking at the totality of the circumstances. You know, when I look at a suppression, the case law requires me to look at the totality of the circumstances, and that's what I'm doing. And it pains me to say this, but the totality of these circumstances demonstrate gross negligence and incompetence on the part of the defense team. I am unsatisfied with your representation of Mr. Allen. Wow, 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 wow. I am greatly concerned about his rights to have competent, non-negligent representation. He currently does have that right. Now, because what you have demonstrated is negligence and incompetence, now I am sharing my thoughts with you privately, right? She's saying it privately. I don't want to say this in open court. I would encourage you to talk privately about what you wish to do. I don't want this coming out. It is not where we need to be with this case. but I will. But you don't know that. You have just now been made aware of my concerns and where I am landing. So if you wish to have a private conversation, I would encourage you to do that. I don't believe your client is here yet. No, he's not. Clearly, you need to speak with him as well. So, Baldwin, I'm not good at reading between the lines. The judge, you're a lawyer. That's what you do for a living. Wow. Baldwin, when you say have a private conversation, are you talking the four of us? Or she goes, I'm talking about you. I'm not accusing the state of gross incompetence and negligence. I'm finding gross incompetence, negligence with you. Oh my God. Oh, sorry. I jumped ahead. I'm entertained a little right here, and that made me jump ahead. Baldwin. So, okay. So, Rozzy, forgive me. Go ahead. Baldwin's like, no, no. Rozzy, I mean, obviously reading the tea leaves here, what you're giving us a chance to do is bow out gracefully, if you will, if that's the right term. Is there a scenario where the court would accept if I stayed in the case? I mean, I'm a team player, and I'm not the kind of guy that just bail out on somebody just for the sake of doing it. But I think it's obvious that, he can speak differently, but I'm not as connected to some of, this most recent circumstances as he is. Mr. Allen is in a situation where he is going to have counsel. That's if he has a new counsel, it's going to take them a year to get up to speed with the depth of information that continues to come in, right? They keep getting more information. And so I think that his Sixth Amendment rights matter. And, I'm probably the one that can at least move this thing forward with some sense of judicial economy. I don't like it, and that's not what I intended to do when I came in here today, but that would be kind of a worst case scenario on our side, I guess. And so that is an option that the court would consider, or I'm sorry, would entertain? No. Rozzy, so basically what you're saying is you guys either quit on your own or you make me fire you. That's what? No, I'm saying to you that this is what I plan to say in court on the record when we convene at 2:00. Rozzy, well, so are in the culmination of that you're removing us from the case. I will, based on what I've just shared with you. Rozzy, okay, well, I just want to make sure we're the court, and I'm not just giving you the opportunity to have a conversation, which how do you want that to go? I don't want to do this. But I will if I have to. Baldwin, how would or should we bow out gracefully? As Brad says, how would we even have a hearing? How would that go? Because if we're out of the case, then, Rozzy, then you're going to go ahead and rule on a bunch of stuff without lawyers in the room. That's no, I would not do that. If you decide that your best course of action is to file a motion to withdraw, you can do that today. And I'll send Mr. Allen back to Doc after you've had a chance to speak with him. Baldwin, would that happen before the hearing or after the hearing? That's your motion to withdraw would happen before the hearing. Baldwin, okay, that's what I wanted. Yeah. Yeah, because he has rights, and I don't want those rights compromised by having a hearing with him not having counsel. I assume if you choose to withdraw that his financial situation hasn't changed and he would still be entitled to court-appointed counsel. I can't imagine that he has the ability at this point to hire counsel. I don't know that. Baldwin, Brad and I need to go talk. The court, yes, you do. Thank you, gentlemen. McLeland says, yep, thank you, Judge. So it says off record. The court, thank you, Jody, the court reporter. You're welcome, Judge. Okay, yes. Rozzy, all right. So obviously we're kind of trying to figure out how to address this issue with very short notice, very little notice. The first thing we did is really to talk to the client. Our client is a big part of this, the biggest part of this, and he has communicated to us that he does not want us to withdraw from this case. He wants us to continue with his representation. He understands, I think, that he's not the gatekeeper, or he doesn't have the authority to really force the court to do that. He would like to say that on the record, we asked him if that's what he wanted to do. We suggested maybe he would do it in chambers. It seems a little bit of a difficult position to put a man who's accused but not been found guilty, put him in a courtroom and have him, have to speak in the circumstances with 15 minutes notice. Andy and I am going to speak for Andy. I'm going to speak for myself. Let me go down. I'm going to file a motion withdraw. I don't want to do it, but I don't think that I have a choice at this point. The option I've been given without any notice by the court really are either I withdraw or I'm going to be publicly shamed. And that's the way I see this. And I think that the public shaming is there's not only a professional element to that, I think there's a personal aspect to that too. But when the media is tied up like this, and we show up here today with the court having told us that we're going to conduct some business, that the somehow bleeds over into a forced resignation or whatever you want to, however you characterize this, that, I don't feel like I have any other choice professionally. I have a life beyond this courtroom and beyond this case. And I have a family too. And I have a law practice. But I think we'd been given some notice of what we were actually, if this would have been framed in a pleading format or some formal disciplinary claim, which there's a process for that in our business, then we could have had had come in here today with an opportunity to refute some of those things that you clearly had, thought through and prepared before we got here. And we didn't have that opportunity. And that's the idea that I'm going to have to go in here in an open courtroom and essentially defend myself against claims that I don't agree with without any notice and without any opportunity, I think is unfair. But I also have some common sense, and me going in there and standing my ground because my client wants me to just going to make things worse for him. And so I'm going to withdraw my appearance. I'm going to walk out here and I'm going to go down to my car. I'm going to call my staff and have them prepare a motion, and I'm going to withdraw my appearance. But I'm doing it because I don't think I have any other choice professionally, not because I want to and not because my client wants me to. And I respect the court has an opinion, but we're professionals and we can disagree. So the judge says, of course, Rozzy. And, I am extremely, I'd say frustrated, probably a soft word, with the idea that we showed up today without any real opportunity to prepare for any of this. And I just think it's improper, and that where I am, and that's my opinion. The judge, well, I think we talked about when you asked for a disqualification, and I indicated on our phone conversation, I'm inclined to do that. So Rozzy replies, it was a phone conversation that was not on the record, and then some follow-up emails. The judge says, true. There's an informality to that. True. And you also said that you hadn't even done any research and you hadn't, had time to talk to your senior judge and all these other things, and hasn't filed a pleading with the court either. Says, no, I'm doing this on my motion. So Rozzy says, and I'm a lawyer who's practiced in lots of courtrooms, and I've been through some disqualification activity. In 20 years, I've never had a disciplinary complaint in my life that's been confirmed, if you will, but I've seen lawyers disqualified, and there is a process for that. And it's not this, with all due respect, where you walk into somebody's office, a judge office, and they read a prepared statement to you. And essentially, that statement is an indictment on my professional, activities. And then you're handed essentially a sheet of paper with two options. And one of them is, I'm going to go out here and shame you, or you can quit. You can understand how upset that would make any lawyer. And I don't think it's right way to handle this from a due process standpoint. So I have no choice but to, withdraw my appearance, because I'm not going to go in there and take a public shaming without having any notice of it. That's where I am with it. So now here's Baldwin talking. I'm in the same withdrawing. I mirror what he said. I mean, I do appreciate giving us the advance notice. If there is some appreciation for that, I do appreciate that. But beyond that, I wanted to take this, and finish it out. I'm stunned. I don't know what to say. So I'll just say, I'm moving to withdraw orally. She says, okay. Rozzy, is the court gonna generate some further instructions on what to do with all of the discovery that we have? And she goes, I already have. Rozzy, all of this information, and there's an order I granted on the state's protective order on discovery. Rozzy, no, I'm talking about my possession of all of this information, and I'm to take it out to the trash can. Am I supposed to wait for another attorney? Is the court going to give us some guidance on how to move all of this information from one law office? She replies, I did. To another, the court, which I granted the state's protective order. I think it's the last paragraph of the protective order, directs you to return it all to the state of Indiana, and the copies, all of the whatever you gave them, they are required under the order to return to you. Rozzy, and the conclusion of the case, at the conclusion of the case, the court says, or your representation. I know that order you're talking about. I read the order before I came today. Isn't that interesting? Okay. So we're supposed to just take everything back and give it to the state and then just retain our work product until somebody asks us for it. Your work product is your own work product. I mean, I would hope that you would share that with the successor council. I would hope that you would help the successor council just with the transfer of all of the information, because that's in your client's best interest to do that. But that's entirely up to you. That's your work product that you have developed. I mean, clearly the discovery is required to go back to the state. Rozzy, okay, thank you. What do you want to do with Mr. Allen? The court, I can transport him back to the Department of Correction. Rozzy, do you want to make a record with his, I think it is appropriate that the court let him speak into the record his thoughts, unless the court just accepts that as notice that those are his opinions. The judge, well, you wouldn't lie to me about that. Rozzy, I would not lie to you about anything. Oops. Rozzy, okay. She goes, yes. Baldwin now responds, so we're going to leave, I guess, and you're going to, how is this? You're just going to get up and on the bench and say, I will just indicate to Mr. McLeland going to be in there with Mr. Luttrell, and I'm just to say that we had a turn of events and defense counsel was withdrawing, and that's all I'm going to say. Baldwin, can you wait for us to get out of here? The judge, of course, and we can have you, I don't know where you're parked. We have a hearing set for October 31st that I'd like to keep as trial setting and appointment of new counsel. And if you can get things together by that date to return to Mr. McLeland, that would be good. Otherwise, if with your permission, I will give the successor counsel your contact information. Baldwin says okay. Rozzy says okay. Court asks, where are you parked? Rozzy, nice to meet you. Sorry to an inaudible. Luttrell says something inaudible. Baldwin, just right out there in front of the building. I mean, there's a parking lot. There's a little parking lot right in front of the building. I don't know what. I always hit that too far. Everybody's in the courtroom, so I don't think that there's anybody out in the hallway. Rozzy, I'm going to get my staff member. I'm going to have her. I don't need any. Well, why is it not moving? There it goes. Revenants at some point and try to get the stuff back. Okay, that's fine between Steve and I and Sarah, says McLeland. Rosie, okay. McLeland, we will get it all. Rosie, that's fine. McLeland, done. That's either Sarah. Rosie, thank you. The court, thank you. This concludes the procedures that had in camera on October 19th of 2023 in this case. And then behind this is a certificate from the reporter from Allen County saying that she took the transcript information on that day and she certifies the transcript reading, right? Then this is verification. Record of camera proceedings, October 19th. This is signed by Matthew Goodwin. He is the attorney for Judge Gull. That's who's representing Judge Gull. And I actually know him from a previous job. But anyway, and then they certify the information showing that it was filed electronically and to whom. So very interesting, right? We've got the information there that she filed. So it was recorded. They did talk about what was going on. I think that, we got to remember that the discussion in there obviously shows us that the Indiana State Police are still conducting an investigation in regards to the leaks. We know that one of the people that had leaked it, right, that came out of Baldwin's office. I think it's interesting that Rosie's like, I had nothing to do with this, right? Rosie has nothing to do because I don't know these people. I don't whatever, right? It's Baldwin's friend who takes the pictures, gets the information. Then that accidentally, that information goes from him to the guy here in Indiana, who then he turns around, sends it to the guy in Texas, right? The guy Mark in Texas, the guy in Indiana. They classify him as R, but I won't say more about him because that's not really what he goes by. But anyway, he sits there and he has this information. It goes out. That information then sits here and goes out to other people. And obviously, we've learned more that, the other specifics and stuff out there, that it was then notified to the murder sheet that this had leaked out there. They find out that it's leaked out there. They confirm that a YouTuber also has this image, and they talk to the state police, and they give the Indiana State Police that YouTuber's telephone number to speak to. And when they talk to the state police, the murder sheet sits there. They delete their copy of the image and all of that, and talk about that and are talking with the state police officer while they're doing that. So it goes out further, and now the information is floating out there. I'm not going to get in the middle of whatever is happening out there, but that the YouTuber had shown an image to somebody, and then for some reason at that point, then this person who was supposed to be shown it somehow got it, and however that they got it, they forwarded it out to other people, and it was learned that went out to other people. So when the case talks about a continuation of it still being distributed, that's what the heck they're talking about. But if you listen to it, Rosie's like, I have nothing to do with whatever's going on. And then we know that Baldwin's talking about in here, he knows that information accidentally went to Woodhouse because it was supposed to be going to Brad. And so who do you think this email went out to instead that had discovery and information in it? Well, it goes out to Woodhouse, who had that information and was trying to notify the court that they had discovery information, right? So somehow he has this. This is right before all this is going down. And in the middle of this kind of all this ordeal, we have the Franks hearing that's released that was supposed to be redacted by the defense team. It wasn't redacted. It was sent on non-redacted. And not only did it describe the crime scene, which at that point everybody thought was shocking, because this was before the crime scene photos got out there. They thought that was shocking. Well, the other thing that was shocking is they revealed the actual names of witnesses, right? They list the names of witnesses, which you want to protect witnesses. And so it'll be interesting. We're getting closer to the case. I think this is also why all of these materials are being developed, and that's why the judge, because she's still working as a judge. Remember, she's not the original judge. She was a special judge asked to be put on the case. She is still sitting here working, doing her job, in addition to having to deal with all of this crap that was created because of the defense's neglect of protecting the information. No matter what, it was because of the neglect that they did for that information. So thank you for being patient. It's hard enough for me to try to see and read this on the computer screen and move it while I'm in StreamYard, because other things pop up, and I don't know whether you guys can see when stuff pops up in my way while I'm trying to do it. But so I appreciate your patience, but we got through it together. I found it interesting. I'm curious what your guys' thoughts are. Tell me your comments on that. What do you think should happen when the Supreme Court comes? I mean, I think that the judge, it's, you don't get rid of a judge because she decides to get rid of people because of information like this that gets out. She's named, and we've seen other issues that she's had with this defense team that she tells them verbally, hey, you talk about you don't want it in the media, and then you go right out in the media. We all knew that's why that gag order was issued, because they sat there and had a press conference about it and started talking to the news like crazy. That's definitely explained why they did the gag order. So I tell you guys, it is amazing to me. And remember, because of all of this that's going on, please remember, we don't know all of the evidence that the prosecution has. So there's a lot of people trying to say, because of all of this, which I don't understand, I don't get it, because of all of this, they think that Richard Allen is innocent. Now, I want the truth. That's what I want out there. I want the truth that's out there. And I don't want it to be a case that is done in the media and is done, diagnosed by people who only have partial information, which all of us, everyone, anyone you watch only has partial information. They don't know everything in there. You saw what it said about the defense team was saying how information is dropping all the time. Well, you know what that information is, guys? That's evidence. That's forensic evidence coming out, whether it's digital evidence, whether it's DNA evidence, right? Whatever type of stuff that it is, whatever they found in the house, whatever in there. Now, if they turn around and they come back and they go, guess what? There was DNA and it was Richard Allen's and was found on the scene. Or what if they come back and say, hey, we went in and we found all his electronic devices and we saw him communicating with Libby as Anthony Schatz, right? Or we found a connection, or, anything like that. You don't have all of the prosecution in there. They have not got to come forward and say their stuff, because they're not supposed to, right? They're not supposed to. Now, we have to remember that. and it has to be a fair trial. Don't hear one side of a lot of bull crap out there and then think that they know that somebody's, honestly, whether they're innocent or guilty. There can be a lot of information out there and a lot of stuff they have found since they arrested him last year, October, that they are finding. So I appreciate you guys being here. Thank you for going through this with me and listening to me read this at the last minute. I appreciate that. I will drop the letter document that came from our prisoner who was going to testify on behalf of Richard Allen, but then said if he didn't get protection, then he wasn't going to come forward. He is a registered child molester. I don't say that because that something he could say isn't true, but I am saying that because you have to know who this person is who's coming forward and talking about threats happening in the prison itself. Don't forget that the person who puts Richard Allen at the scene is Richard Allen. Don't forget, when I go through and have shown you guys the probable cause affidavit, which I think I'm going to do that again for you guys, that Richard Allen from the Orion system, which I showed that in that tape or video too, in the Orion system, they pull back out that Dan Dullen had this conversation with this man who says that he's there, and he says he's there till 3:30. He talks about when he arrives there. He talks about getting there at 1:30. The cameras catch the vehicle driving past, going to the PCA building, right? Where he goes and parks. He goes and walks. There are eyewitnesses, right? The eyewitnesses of teenage girls see him. And guess what? In his statement to Dan Dolan, he says he saw them. To be honest with you, that is probably why he came forward to say he was there. He was worried. The photo got out there. The video got out there. They say they want to talk to this guy on the bridge. If you were at the park, you should come forward. He was probably scared to death. So he had to come forward because he knew that some of the teenage girls actually saw him. One spoke to him saying hello and thought he was rude because he didn't say anything. He glared at them. They walked by. The timing of when they walked past him is past the time that he said now that he was leaving. Then when we have the other witness who sees him on the bridge standing over to the side, that is there during that same timeline. That witness leaves. And what does she see when she's starting to walk away? Abby and Libby. Abby and Libby literally walking towards the bridge. So he puts himself there. Then when they go, the witnesses put himself there. They show them the actual pictures, of this. And they say, that's him. He says he's there between 1:30 and 3:30. Well, guess when the murders happen? He says he parks, he doesn't call it the CPS building, but when they figure out and they're interviewing him, that's exactly what they know that it is. He's trying to call it the Farm Bureau building. It's the CPS building. He says, oh, I didn't really see anybody else. I didn't see any cars parked anywhere. I didn't see any of that stuff because I'm looking at a stock ticker on my phone. Yeah, because he's a high-level investor, right? His car passes the camera. He says he saw those girl witnesses. So he confirms that that's who they saw. It was him. He describes a girl. They describe the clothes that he's wearing. Then, then he's on the bridge and he's seen by by the witness Betsy, right? She says she sees him like on the first little side platform area. She walks away, the girls walk by it. I'll tell you one thing that I think is interesting. There are a couple of other witnesses that I know at the very beginning have been part of this case that witnessed someone, but they're not in the probable cause affidavit. Now, either the police identified who that was and it was somebody else, which for one of the two, I don't think so. Or in my opinion, could that be somebody else? I don't know. But anyway, thank you guys for listening to this recording. I will drop it. It's going to show up like a live. So sorry about that. That's just what it does. Or because I don't know how to do it any better than that. And I'm not sure if I'm going to have another show done and ready to do quite before Thanksgiving or not. But if I don't speak to all of you prior to then, I hope you guys have a great Thanksgiving. I hope you spend it with friends and family. I hope you remember that there are people who have missing loved ones or murdered loved ones who will not be at the table. Also, I know that some of us have just had people who have passed on that won't be there with us. And I've have experienced that before, and that's really hard every year, honestly. And my mom being one who every year. And so I wish you all the happiness and joy. If you are celebrating Thanksgiving, I hope you have great times. Enjoy your family, enjoy your friends, appreciate each other, love each other. I always appreciate all of you guys for supporting me and supporting this channel and helping me fulfill my dream and trying to help other people and help other people get the word out about stories and safety and finding people and that type of thing. So, and I appreciate that you guys are always here. And please hit that like button, hit the subscribe button. I got to remember to say that, or they'll all be all over me because I forget to do that. And thank you guys for making sure that justice is served daily. Good night.